software developer and lawyer traditionally viewed as arrogant group. When people show me the AI tools, they were thinking just AI is so powerful. You would be a fool not to use my tool. We have this powerful pattern that very few people understand. From that 100 idea, we might narrow down to 5. Patent portfolio, in my opinion, is also a showcase of the strength of your technology. The idea coming out of Finnish people's mind, American people's mind, Chinese people's mind are exactly the same. One of the example, a recent case, is singular software versus Google, and the ask is $1.6 billion. You can have all the experts in the world look those 3 patterns, and all the experts would disagree with each other.
This is the Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadeo. My guest today is a rare hybrid in the legal world, a PhD software architect and university professor who pivoted to become a leading IP strategist for some of the world's largest tech companies. Formerly with Nokia and Here Technologies, he now serves as senior IP counsel for Tencent America, where he safeguards the innovations of a global giant in gaming, AI, and social media. It's my pleasure to welcome Hongming Liu to the podcast. Welcome, Hongming, and thank you for being here.
Thank you, Aniket. Thank you for the introduction. I'm glad to be here.
Yeah, likewise, I'm glad to have you. Hongming, as you know, I like to start by asking each of my guests to share either a fun fact about themselves or a cringe joke. Which will it be for you, and what is it?
A cringing joke, of course,
Please.
and my
Love it.
teenage son was so afraid of me telling cringing joke. Every time he's with a group of friends, he's looking at me like, don't. So he was just with a group of his friends outside at the park, and they happened to get a shovel somewhere, and they were digging up something. And I walked to them, and my son was looking at me, but I go ahead and I point to the shovel and say, that is a groundbreaking tool.
Yeah. Oh no, shovel is a groundbreaking.
Naughty.
Oh my gosh,
I get by.
that's one of the best ones I've heard all year. That's fantastic. Well, thank you for sharing that, Hongming. All right. Well, and then the next question I like to ask each attorney or each guest who makes the time to be on my podcast is that I consider each attorney who makes the time to be on my podcast as a superhero, and every superhero has an origin story, and I know that yours is very interesting. So, would you mind please sharing it with us?
Yep. And it all started when I was graduate from college in China. I come to United States as graduate student. But before I came, I remember I was at the train station in Shanghai. And on my left side, I saw a sign called in Chinese, jumping on the rail is prohibited. On my right hand side is the Nike advertisement, just do it. So that is the story of my life. I'm in between, right? I'm in between China and the US. When I started graduate study on computer science, and then I switched to legal, I'm in between the technology and the law. And that is also the reason I make the switch, because I want to broaden my perspective, because I saw computer work exactly the same in US or in China. So I come to China. I want to learn more. And legal, it goes to how the society works, how people interact with each other. So for me, it's almost a no-brainer. But there's also origin story. I think that's the first couple of days when I get to Chicago. I was so excited. anybody on the street at the bus station asked me how long you've been here, I had a ready answer like 1 day, 2 days. When it reached 10 days, I realized the guy at the bus station was asking me how long I had been waiting for the bus. I thought in 10 days. So it's perspective, because I was in my own perspective. The guy at the bus station is in his perspective. Everybody has their own perspective. And that is really the origin story of me pivoting into legal, right? Because I'm bringing the perspective of being a software engineer, being a college professor of computer science into the legal world, IP world. And I really enjoy it.
That's great. I mean, there's a couple of things that really stood out from what you just shared there, Hongming. One of them is obviously the perspective that you mentioned. Perspective that you're answering a particular question versus the perspective that the bus driver in this case was asking the question. That's very important, and I'm sure we'll touch upon that later in this conversation. But something else you said in the beginning was also fascinating, which is that just as computers have worked the same whether in China or in the United States or anywhere else in the world. They're governed by operating systems which sort of govern how they operate, right? But what you said there, if I may paraphrase, Hongming, is you said that laws are often like the legal space is like the operating system for society, which is just a fascinating way to think about it. So no, that's very profound. We'll try and come back to that in a little bit. Okay, great. So you're in Chicago. You've been here for 1, 2, 10 days. What does your journey look like from your education and then through your various roles up until today?
So yeah, after I graduated from the Paul, getting my CS degree, and I was lucky because usually people go to firm after a law school, right? Work in the firm and then go in house. But because I had my tech background, so I was able to get a role in Nokia as a patent engineer. So kind of like the role itself is combined technology, and I was still a law student at that time. So I went into that role, and then after I get my law degree, naturally I'm just becoming in-house counsel. So I was lucky in that way. But also the flip side is I never get to actually practice in a firm. So I always think that's my weakest link, right? So, but I enjoy I enjoy the work of in-house because I work very close with the engineer, which they pretty much speak my language, right? So and especially in IP, so it's so technology specific. So I find that for me, switching from technology field to the legal field, it's not really pivoting. It's almost like naturally I just apply what I know to a broader areas.
Makes a lot of sense. You mentioned that your first role was as a patent engineer. For those of us who may not be aware of that role, what does it entail, and how is it different from obviously the roles that you've taken on since?
Yeah, good question. So patent engineer is a role that a lot of company naturally adopt because they have the talent to engineer. So engineer file patents, right? And the in-house lawyer help the patent harvest those invention and eventually work with outside counsel to get it patented. So the in-house counsel was like the liaison between the engineer and the outside counsel. So just imagine an engineer itself can do that job, right? So we
Mhm.
actually cut down, we make one the first step really connect seamlessly because from engineer to in-house counsel. Just imagine that in-house counsel is also a formal engineer. So that's why in a lot of companies like Nokia, they just actively recruit people in engineer team. And we have this patent engineer. All you need to know is your engineer technology knowledge, and also we will train you about the patent side. So either go to school, we have the team will help to train the person on the job. So after a couple months dealing with the day-to-day work, engineer can very easily switch to patent engineer role. So that's actually very uh, 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 effective way for corporation to cultivate the inside talent. So I happen to be kind of get into that track. So, but I know that a lot of corporation actually using that. So I would say that in the most team I see, there's about a quarter of person is going through that track, like from a patent engineer becoming in-house counsel, versus a, a majority is still a lawyer coming into corporation as a patent attorney. So so the track is a good complement.
Yeah, it sounds like it, because especially for someone like you who had the engineering or has the engineering background but had a strong interest in moving to law. So it's like a perfect, it sounds like, as you use the word seamless, like a seamless transition, not just in terms of communication for the company for all these inventions, but also a transition for you in terms of your career trajectory. So that's great. You mentioned a term in there which I wanted to talk about, which is invention harvesting. Now, and so we'll come back to that term in a second. When you were at Nokia, obviously Nokia is a company, a legendary company that has gone through many shifts, throughout the decades. When you were at Nokia, were they more in the consumer market, like with the mobile phones, or were they more on the back end hardware infrastructure, which is maybe more of their recent, sort of product line?
Yeah, it's interesting. The first day I joined Nokia, I remember it's the day they announced that the phone business is sold to Microsoft, I think.
Yeah, that's right.
So,
That's right.
yeah. So I joined, and the next day Nokia that's wasn't the same Nokia that we know about. So, but we still have big patent portfolio in terms of technology other than the phone. So I remember the team I work with is actually in Finland, Tampere, Finland, and they specifically do some location technology that helping, say, a device to gather the location information. So a moving device can keep getting the location information, eventually can draw a map of
Right.
the indoor area. So that kind of technology. So so I was helping that team specifically doing invention harvesting. Because they were doing their day-to-day work. At some point, they might think, "This is a new idea," but somebody need to take a look to actually decide. We can't just file 100 patent a day, right? They have 100 idea every day.
Right.
That's what
Yeah.
they
Yeah.
but from that 100 idea, we might narrow down to 5 decide to file patent. So that's what we come in as a patent attorney to really help the engineer while they were doing innovation. We look at from the patent point of view and harvesting the invention out of their work. So that probably touch the harvesting part that you mentioned.
Right. Right. So if I understand correctly, again, that term is new to me as well. So harvesting essentially is the idea, the concept of looking critically at all the different ideas that an engineer or engineering team might have, and then deciding which of those are maybe worthy of taking to the next step, almost like a funnel, maybe, in terms of, all right,
Exactly.
here's what we
Mhm.
think is defensible in terms of an idea. Here's what will make it potentially through the patent
Yeah.
office, like that.
Yeah. I think that's the most we as in-house patent attorney uh, uh, show our value, because otherwise we didn't obviously come up any invention, right? And but we really help to pick out those that's valuable because we have the knowledge of the patent side. And also I think that actually touch one of the thing that I want to mention, because in software, so I deal with a lot of software patent. So in software patent, I think we have a huge just problem just in our field. We have generated so many patterns that it's very hard for anybody to understand. Because when software engineers do their job, they are coding, right? They are coding. They're not inventing. So to make their work into an invention, it's really hard. However, a lot of software companies are filing a lot of patents. So in that process, what people really just ignored is really the value of that patent. Instead, everybody was chasing the number, the quantity. So that also, if we look at patent office side, the examiner has to look at the patent application and decide whether to grant it a patent. Just think about how many examiner will be able to really understand software patent. For example, say quantum computing. You can't expect every examiner to be trained about the latest quantum computing, right? So you will see that most people are not be able to understand that in very timely manner. So, but we're processing thousands of patents anyway, granted. So we have this pile of uh, uh, pattern that very few people understand, and and some of them shouldn't be even patented because we need a number. So, and then talk about litigation. If somebody use one of the patent to sue whoever, think about it. You have something that is very vague because the software is intangible. But then you describe in a patent language. That claim language is very awkward to describe the original technology. So you have something that really vague, which can go either way, which can make it a very weak weapon or very strong weapon. Depends how you interpret it, right? So that's I think it's a huge problem. So when I think of litigation.
Right. That's a great point that you make in terms of the connection between innovation harvesting, which, if done correctly, ensures that you only have the highest quality patents coming out of your group or your company, as opposed to software patents, which, if the idea of harvesting is not applied properly, then you have, as you've mentioned in other forums, a lot of bad patents, patents that are vague. Patents don't actually serve to protect an invention. They're just kind of put out there because somebody said we need to hit, I don't know, 20 patents this year or whatever that number might be. That's very interesting. Something you mentioned, and something I wanted to touch upon, which is that, so after Nokia, which is obviously hardware and infrastructure, and for the most part, you then move to Here, which I believe is a mapping, among other things. They do mapping technologies, right? Because I know that my vehicle, for example, uses NAP from Here and things like that. And so and then obviously now you're at Tencent, and so, which is in terms of consumer software, media, gaming, that sort of thing. How has the nature of the work that you do, innovation harvesting, making sure that the patents that are published are not bad, etc., how has that nature of that work for you changed as you moved across these different companies?
Interesting question. Because look, when I look at these three places I work with, one is a Finnish company, one is American company here based in Chicago. So it's part of Nokia, so it was divested. But anyway, that's a separate company I work with. So American company, so Finnish company, American company, now Chinese company. So all the same role, patent attorney, doing the same thing, patent harvesting, prosecute patent application. And honestly, I hope that people can benefit from my point of view is that they almost exact the same. So you can forget it's a Finnish company. You can forget it's an American company, you can forget it's a Chinese company. Right? From my point of view, my personal experience work the same because the technology is the same. So when I work in Finnish company, the inventor will be Finnish people in Tampere. And when I work with Chicago people, inventor in Chicago and the inventor in Shenzhen, China. So I'm working with the idea that come out of their mind. So the idea coming out of Finnish people's mind, American people's mind, Chinese people's mind are exactly the same, right?
Yeah.
It's amazing, right? When you look at the idea, it really make no difference what kind of people they come from. So, but it's kind of surprising, even for me. It will be so similar, like my day-to-day work and how I feel out of work and how things are going. Because every corporation have different culture, right? So, but still the similarity trump everything.
That's a fascinating insight. Yeah, I would never have thought. I mean, those are three different companies doing three different sort of in three different, areas of technology, hardware, software, and consumer, so to speak, and then across three different continents, quite literally. But the fact that your work is more or less the same in terms of how you approach it, that's amazing. Do you think, Hongming, that that's because you're working with those ideas and then you're sort of working within the framework of the US Patent Office, or do you work? And so, a side question to that is, do you also work on patent regimes outside of the US? And is that your dropping the similarity in the book?
Yeah, I think working with U.S. patent system has a lot to do with how my work goes because every strategy was tailored against how can we get more patent in USPTO, right? So the culture was shaped that way. I think that's probably it because all my work was just going around this patent system, which is um, globally the fundamental are the same because a lot of patent system they actually uh, kind of copy each other. The Chinese patent system is almost the replicate of Germany. So because when China doesn't have a patent system, they need to set up one. So what about all the rules? What about all the roles of people in that department? So they look at Germany, they just copy the whole thing. Because as long as we can have a system that kind of look like other people, it's better for globalization, right? So so that being said, I'm sure so when Germany set up its patent system, it really kind of referred to the US one and some of the rule setting as well, because and also the organization trying to have some unity. So I think we're lucky. The pattern is one thing that people can very easily agree. Different country people can very easily agree. But also as a lawyer, we also know that sometimes it's the minute difference that make a huge difference. So that's why we I'm a US attorney, so I can only prosecute patent in the US PTO. So if we need to get something patent, say in India, we have to hire local attorney. Even we think, oh, the patent system might be similar, right? So so that's the other side. Every country can have its own rule, and so much so that we have to have the local attorney to prosecute a patent application for us. So that end up my day-to-day work will probably look different from Indian patent attorney or Chinese patent attorney.
Makes a lot of sense. Staying with the cross-border theme for a little bit, right? So obviously Tencent is a huge company in China and many other parts of the world. As far as I understand, they do not have as yet a significant presence, in the US consumer market. But that being said, I also understand that, Tencent has a very large US patent portfolio. So can you maybe talk through the thinking there, like what drove Tencent to sort of have this US patent portfolio, even though they don't have a significant as of yet presence in the US market?
Yeah, good question. I think for a lot of, say, Chinese company, so even if they don't have the same product in the United States, patenting in US has couple advantage. Like first, it gave kind of recognition. So patent portfolio, in my opinion, is also a showcase of the strength of your technology. So that's why people go for the number. So your ability to get that amount of patent. So for any company, and so to 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 just say you are a global player, so you will have incentive to patent quite a lot in the U.S. So that's why even Tencent has no product selling in the U.S. Also, for a lot of company, eventually they were thinking about growing. For example, Tencent is growing in the gaming area in the US and quite successfully. So for strategic reason, you can't to you can't file when you uh, already have like a product in the US and think, oh, what if we filed 10 years ago, right? So that's people are prepared for the future. So I guess especially a lot of areas, Chinese corporation is expanding. So filing patent in the U.S. is still very strategic choice for a lot of people, and they see the advantage. Also, the value of U.S. patent is still quite high. Like so, what even for two company that maybe both doesn't have anything in the US, but when they fight in China, right? Uh, Not literally fight in court or something, but they be negotiation. In the negotiation, the having patent portfolio in the US is a show of force, right?
Makes sense.
Then why not use it? People spend money to strengthen your brand. People spend money to strengthen your patent portfolio. It's the same thing.
Yep. No, that makes a lot of sense. Thank you for sharing that. Switching gears a little bit to AI, right? And so AI patent related litigation and that whole space, right? And so I want to go back to what you shared at the beginning, which is that, hey, you have your sort of hardware type patents, and maybe those are more like inventions. And then you mentioned that, software patents can be, there's a layer of abstraction there that has to be converted into language that the examiner can understand. I would argue, and you could maybe push back or agree or disagree, is that AI would be even a further layer of abstraction, because at the end of the day, even if we operate models, we sort of have an empirical understanding of how they work, but we don't really know why they work the way they do, right? And so I guess, what are your thoughts around just litigation related to AI patents? And there was a huge change in the IPR, I understand, that makes invalidation harder. So can you maybe share your thoughts a little bit on that whole space?
Yeah. So that's recently on my mind a lot. It's actually a little scary. It's a little scary because like I know that there's so many kind of weak pattern out there, but there's just so many of them. And all of them could be used, as I said, when it being used, it could be really strong or could be very weak. But the most scary part is nobody can tell. Like that that's scary. That just means it can go either way. And one of the example, a recent case, is singular software versus Google. So it's this one single inventor who has couple invention on the TPU's architecture. So it's the most advanced AI stuff. And as somebody who's aware of technology will know that 3 patents shouldn't cover, like, it should cover very few. Like, you are one person, and just think about Google has how many people work on that architect, right?
Yeah.
1,000. 1,000 software engineer just as competent as. I'm not saying that inventor is particularly weak or something, but anyway, he can use this 3 pattern through Google and saying that the Tencent process unit kind of infringe his idea on that, right? If we look at the plain language, it's just unclear. Nobody can tell. Nobody can tell for sure. The court took a look and, of course, just let the litigation go. At that time, the IPR process is still a viable device. I think in that particular case, the IPR's process invalid, say 50 claim, but there's still 10 claim left. So invalidate a big chunk of it. But as long as there's one survives, the litigation can go forward. So the litigation go forward, and the ask is $1.6 billion.
Wow.
$1.6 billion. And it goes to the jury trial. Of course, we have all the discovery years, tons of money already goes in the jury trial. And still, nobody, you can have all the expert in the world look those 3 patterns and look what Google is doing. And all the experts would disagree with each other. Some will say, I think it infringe. I don't think it infringe. And that's the thing. Nobody knows.
Yeah. No, thank you for sharing that, because just for the purposes of, knowledge for our audience. So this patent refers to, is related to the TPUs, which are, as you mentioned, the tensor processing unit, which are the chips that are used for both the model pre-training as well as for the inference for the at a high level for the AI models that we all use in so many different ways, right? And so Google has sort of famously has its own TPUs, and the rest of a lot of the rest of the market uses NVIDIA. But regardless, these are the reason that these sums, I presume, Hongming, are so big, $1.6 billion, is because the market and the application of all the, the hardware itself, and then all the layers that sit upon it, and just the global application of it, just so massive, So yeah, thank you for sharing that sort of backstory of that. Switching gears to another aspect of AI, not so much within litigation itself, but more on the side of legal practice. So, you spoke recently at the Technology Patent Network about on a talk titled "When AI Tools Can Help Manage Your Legal Practice." So, I guess what is, given your very strong technology background, where do you think that AI tools stand in terms of assisting attorneys with authorization analysis, legal research, drafting? What is your take on
Okay. Yeah. I think generally, also part of my observation as well, I think the law firm side is moving a bit faster than the in-house side. So in-house side, we're not in any way adopting AI tool because for one thing, our work, how fast we do our work, is not makes not a huge difference. We 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 will pay the same salary, right? It's like the fact we can do our job super fast, super efficient. It's just not too much motivation for us. Plus, the tools are not there yet, right? So we wait. So all the in-house counsel wait. But the law firm, it makes a huge difference. If they can do something 1 hour to do the 10 hours work, they have to use it. Otherwise, the competitor is going to use it. So I see law firms are actively adopting tools. But the thing is, I don't see this successful developed tools yet. Although the needs is there, I'm sure eventually some very good tools will be adopted by pretty much all the law firms, but they are just not there. And the thing I want to really stress is also the disconnection between the software side and the legal side, the two culture. So uh, it's interesting. Every time I'm with a group of, say, lawyers, and I will ask them, like, because these are two very arrogant group of people. Software developer and lawyer traditionally viewed as two very arrogant group. But then I ask, what do you think? Who is more arrogant, software engineer or lawyer? So with a group of lawyer, I often ask that question, and then I'll tell them it's the software engineer. I wish I can tell you why, but you guys just wouldn't understand. That's the that's the arrogance of I see that the people show me the AI tools, but they were thinking just AI is so powerful, you would be a fool not to use my tool. But then it's not even doing what I want, right? So but also the lawyer side is also hard to communicate because they are used to, like, because I'm doing things this way, that's the right way because I'm the lawyer. Who else knows how to do this? So they don't want to even change a little bit to adapt to a very powerful tool. So both sides has some compromise to do. You have to get to know the customer's needs. The customer has to change your behavior so that you can take full advantage of this tool. So I think they're still in the process.
Makes a lot of sense. That's a great segue, Hongming, into my next question, which is, in your experience, not the kind of engineer that you were, who was always interested in law, but just sort of one of those interesting personality types of engineers that you mentioned. Do you see that some of them maybe view this whole IP world or sort of invention harvesting as, hey, a distraction? I'm here trying to build stuff, and I don't want to be, I don't necessarily want to be spending time on this. Do you see that from engineers who maybe if you talk to them, they're so focused on what they're doing that they don't want to necessarily spend time on the IP side of things? And if you do, then B, how do you sort of work with them and convince them that this is actually, the work that you're doing or the work that IP counsel do is actually valuable to them and to the company?
Thank you. That's a very good question. It's actually one of my daily struggle. I work with software engineer. They don't like pattern. Software engineers don't like pattern. And you cannot blame them because it's nobody go read a pattern. Like they will go read a article in some journal, right, to see what the newest development. But nobody is gonna read pattern to find out what other people are doing. So they just don't see the benefit. Like and another thing is when the lawyer put the invention into the claim language. So the inventor doesn't understand. They read their own invention and they don't understand. So the next time you go to them, they will think last time you patent whatever I was doing. After you patent it, I don't even understand my own invention. So what's the point? Like if they really think, they will see the problem. It is a problem. The fact that inventor cannot understand its own invention is a big problem. And that problem hugely just because we cannot translate the software language effectively into a plain language. Nobody can do that. It's not anybody's fault. But the result is inventor does not understand invention, their own invention, so they don't see the value. But for me, I have to do my work. So personally, this is the strategy I adopt. Whenever I talk to a group of software engineer, I told them that my job is to document what you do. Because you're coming up new things every day. I don't want you to think about invention. Just think about this is the idea. I'm helping you document it. Once we document, it has value for the company. So now I sit down with you, I get your newest idea, and I will take care, patent it. I'll help you document your best idea. And that way we communicate very well because now they are not thinking invention. They are not questioning themselves. Like, I didn't invent something. I didn't invent something that I don't understand, but they do understand your work need to be documented. So
Yeah, no, that sounds like a great approach, and I can see how that can be successful with many types of software engineers and developers. Well, Hong, this has been a wonderful conversation. Just a couple of quick questions to sort of close us out here. First is, what advice would you give to an early career, somebody who's early in their career, maybe as an engineer, maybe as an attorney, maybe they're standing on a railway platform in Shanghai or Chicago or wherever else in the world and thinking about where they want to go, and if they should make a switch potentially from engineering to law as you did, what advice would you give to somebody who's in that position and considering making that switch?
okay, somehow a story jumped in my mind. I think that story can incorporate everything I kind of think about personally. I hope other people can be inspired as well. Because so when I was doing my PhD dissertation, before that you have to make a proposal. It was very difficult for me but the best advice I got from my advisor is that he told me just come up something, one, that's significant. Two, that is something new. Like nobody has come up with that before. Like significant and original. Just think about those things. So every time I present something and you will take a look and say, oh, this is original, but it's not significant. Or this is significant, but it's not original. So I keep coming back. One time, finally he said, this is original and significant. But the original part is not significant. The significant part is not original. It just anyway. But when I was doing my PhD, I also had my first child. And when I was in the hospital holding my son, and I looked at him and said, you are actually my most original and significant work.
That's amazing.
I was just saying everything connected. Everything connected. When I starting to do my patent attorney work, when I told a software engineer, what's the idea you come to me? Original, significant. I'm still using that, right? So everything that I do kind of just connected naturally. There's always something will connect with what you do or the path. So for me, it's just that two simple criteria, right? For you might be something else, but just go bravely with your journey.
That's profound advice and very helpful. Thank you for sharing that, Hongming. All right, final question for you. Is there a question that I should have asked you but I did not?
Okay. Yeah, that's it for the last question. My hobby. You should ask my hobby.
Yes.
My hobby is a stand-up comedian.
Coming back to the cringe joke.
That's why I keep telling stories. Like I'm trying to gather all the little stories and eventually used in a stand-up set. This little joke, like
That-
all this can be like just do it, like like the
Yeah.
perspective in the bus station, significant, original. That's all my material. So I'm uh, aspiring stand-up comedian.
That's my best. What does your teenage son think about that?
He only likes my good jokes. So
That's fantastic. Well, good luck to you in your stand-up career and obviously in the rest of your professional career as well. Hongming, this has been a wonderful conversation, very insightful, humorous, just fulfilling overall. So thank you so much for your time. I really appreciate it.
thank you.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.